Hello everyone, it's Sabrilia and welcome back to my channel. So today, I'm still explaining the federal fee state law in maritime cases. The previous video, I have explained the overview of the Pacific Maritime Magazine and overtime wages cement and some of the assumption of the risk doctrine. So today I will continue the explanation about the assumption of the risk doctrine. In Stimson v. Carlson 11 called Apt Ford in 1201 in 1993, the plaintiff crew member on yacht suffered an injury to his arm and wrist during a race when the captain executed a course change and jibed without warning the crew. The plaintiff was able to avoid the boom but was struck by the main seat attached to it. The Court of Appeal affirmed the trial court grant of summary judgment in favor of the defendant, holding the personal injury action was barred by the assumption of risk doctrine. It reasoned a swinging boom is an inherent risk in the sport of sailing, and the defendant yacht captain didn't have a duty to eliminate the risk or protect a crew member from it. The court further held when an inherent risk of a sport is involved, the defendant is liable only if intentionally injuring a participant in the sport or engaging in reckless conduct outside the ordinary rank of the sport. Failing to announce a course change was held neither intentional nor reckless. The defense of assumption of the risk has been rejected by the federal court in other maritime contexts, including suits for personal injuries under the Jones Act, for unseaworthiness, and for negligent yacht repairs. At the same time, the assumption of the risk defense has been recognized by the California state courts in suit involving other marine contexts such as water skiing and jet skiing. Okay, the next explanation is about the punitive damage under the Jones Act. A third example of the disparity of result in cases tried in federal and state court involving the same legal issue can be found in Wagner v. Kona Blue Water Farms, LLC 2010, AMC 1217, D. High 2010, and Larson v. Kona Blue Water Farms, LLC 2010, AMC 1230, Coal Sub City 2010. Wagner was filed in federal court in Hawaii and Larson was filed in state court in California. In Wagner, the federal court held punitive damages are not recoverable in a personal injury action. Brought by a seaman against his employer under the Jones Act. It reasoned punitive damages are not pecuniary damages, not provided for in the Jones Act and precluded by the federal statute on which the Jones Act is based. In Larson, which involved the same employer, a California state trial court held punitive damages were recoverable in a personal injury action brought by a seaman against his employer under the Jones Act. It reasoned it was not bound by federal authorities on the issue, and the recovery of punitive damages was not specifically precluded by the Jones Act. Well, the next explanation is safeguard. Okay, under federal law, a wharfinger or marina owner has a duty to exercise reasonable diligence to determine the condition of a berth and, if possible, remove any dangerous obstructions. Reasonable diligence may require dredging to maintain adequate water depth in the berth. See Pacific Maritime Magazine, a wharfinger studies on September 2009. In Red Shield Insurance Company v. Burnhill in 2009, WL 1458022 NT Call 2009, a federal court applied state law to achieve a result contrary to federal law. Red Shield involved an action for damage to a floating home that grounded due to accumulated silt and mud in its sporadically dredged berth. The federal court, which heard the case pursuant to its admiralty jurisdiction, stated it could not find any federal maritime law on point. Instead, it found for the defendant applying California state law, which only requires marina owners to maintain common areas in a marina, and holding the berths were not common areas. And then, while countless courts give lip service to the need for uniformity in the law governing maritime cases, the desired uniformity is not yet and may never be a reality. The same issues may be decided differently by federal and state courts depending on the law they apply, resulting in uncertainty for those in the maritime industry. Well, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe this channel. See you in the next video, and bye-bye.